Good afternoon, everyone. Welcome to this afternoon's session on disclosure in criminal cases. I'd like to say good afternoon to your ladyship, the Honorable Chief Justice, your lordships, Justices of Appeal, your lordships, Justices of the Supreme Court, the Chief Magistrates and Resident Magistrates, registrars, members of the bar, staff of the judiciary, members of the cargo attending, and all other attendees. A special good afternoon as well to any members of the police service who are here with us today. I'd like to introduce our two presenters this afternoon, the Learn DPP, Eugene Otonie KC, and the Detective Superintendent, Dean Holden. They're going to lead us in two very informative presentations on disclosure in criminal cases. So I'd now turn you over to the Learn DPP, who will begin our first presentation. Thank you very much for joining us.
Thank you, Mr. Emmanuel, and may I accept the protocol you just established and then get on with what we have this afternoon. Good afternoon, everybody. I am presenting this afternoon with Detective Superintendent Dean Holden, Superintendent of Crime, Public Protection, and Strategic Development. And I'm sharing my screen with an introduction that I want to read. And that is that in June 2023, the DPP issued and circulated the draft of the disclosure guidance to colleagues and stakeholders, including the police, for feedback. The feedback on the whole rated the disclosure guidance as excellent, but there was one recurring observation and request: the need for training on the disclosure guidance, especially for the police and prosecutors. And following on that response, I approached my lady, the Honorable Chief Justice and the Chair of the JAI for assistance. And I believe in the spirit and the collaborative spirit of the Criminal Justice Stakeholder Group. She offered us a space, a platform in this year's JAI to kickstart the training. And for this, I am extremely grateful to my lady for this opportunity that you have given us. And I want to say that we are here not to teach you on disclosure in criminal matters. I am here with my colleague, Dean Holden, Superintendent, to discuss the disclosure guidance that I have issued. It is still in draft, and I will tell you why it is so in a moment. And so the presentation focus this afternoon is to use the word of the Honorable Chief Justice, is to unpack the disclosure guidance. We want to unpack it by way of giving it some context and content headlines, and what it all means to ensuring fair trial of the accused and to advance the overriding objective of the criminal procedure rules. The question is, why are we jointly presenting it? It is right there. The conduct of an investigation provides the foundation for the entire case and may even impact on linked cases. But of course, the strategic approach to disclosure that will be taken must always be considered at the start of each investigation. And so I didn't want to take chances with this, because the disclosure guidance is actually a document that guides both the ODPP and the police. And of course, by reason of our independent yet interconnected functions, we are key criminal justice partners with a key role to play in the effective and efficient criminal justice delivery. I've always said that we are joined to the hip with the police. So though we exercise independent, as it were, constitutional function, we are inseparable in terms of how we, jointly together as stakeholders pursue the outcome of an effective, efficient criminal justice system. And so that's why Superintendent Dee Holding will be taking a portion of the presentation this afternoon. Our expectations, because we're not going to teach you, I'm sorry, you may be disappointed if I say so, but I am not an expert in disclosure of in criminal matters. I'm not an expert. And so what we are doing is basically using this distinguished platform to exchange ideas, and including, importantly, the local, regional, and international best practice experiences of our colleagues and the judicial officers in particular. And when it is all done, the takeaway this afternoon will feed back into the final version of the disclosure guidance. And so I would be expecting comments at the end of the day and how we will make it work better in Turks and Caicos Islands and in our system. The DPP's guidance on disclosure in criminal matters. What I want to do now is just to give a context of what informed this disclosure guidance. We have looked at best practices. I have looked at our rules, and other legislative provisions that underpin what you have in the disclosure guidance. The best practice I could look at obviously had to be the mother of common law and the adversarial system that we operate here, and that is the United Kingdom. They've been there for quite a while. And so I usually wouldn't have much choice but to go there and to see how they have dealt with, how they have grappled with the issue of disclosure in criminal matters. And I was forced to go way back, as it were, looking at the early beginnings. And it goes almost to 17th century. That should be 19th century, 1865, where in the case of Arrow and Podick, the disclosure duty began informally on the basis that, and was highlighted in this case, prosecutors must see themselves as ministers of justice, not in pursuit of conviction. And I know that subsequently we've had cases that made similar observations and enjoined the prosecutor to be what is called to be a minister in the administration of justice. And so in that case, 20 years after, in 1946, the UK Court of Appeal criticized the prosecution for not making available to the defense a witness whom they know would give material evidence. I am going a little bit back, to what has happened in UK and to come to where they are now and how it is feeding or will feed into what you already have as the disclosure document that I have circulated. And so in the case of Arrow and Bryan and Dixon, prosecution was criticized for not making available a witness that would have given material evidence. And then subsequently in Dallison and Caffrey, it was Lord Diplock and Lord Denning were involved in this case. And the Diplock was said, if the prosecutor happens to have information from a credible witness, which is inconsistent with the guilt of the accused, or although not inconsistent with his guilt, is helpful to the accused, the prosecutor should make such witness available to the defense. And so the judiciary way back had been raising the concern and basically sensitizing the prosecutor to the need to act fairly, to provide to the accused person all the materials that he needs, which will assist in ensuring that that accused person obtains a fair hearing or fair trial. And so going way back to that 1865 and then down to 1965, Lord Denning and the Diplock made very scathing comments and gave guidance on what the prosecutor should be doing in terms of disclosure. I think prompted by these authorities, the UK Attorney General issued a guideline on disclosure in 1981. It has since been replaced by a 2013 edition. I think it's probably have been revised again. But that was the first time the Attorney General issued a guideline on disclosure. And among other things, it dealt with unused materials for the first time and gave general guidance on how the prosecution should be, the approach to disclosure. But it left a little more discretion to the prosecutor in terms of what to disclose. And remember, that was quite early 1981. So they were at that time beginning to grapple with the challenges and the difficulties in the issue or on the issue of disclosure. The discretion apparently was not exercised properly, and it resulted in disclosure failures by the prosecutors, and several convictions were quashed by the UK Court of Appeal in 1990 and 1991, especially in terrorism cases. And so and one of those cases is the case of Judith Ward, where I don't know if you know the facts of that case. Is Ward during I think when they were experiencing too many explosions in UK, Ward was charged with the offense of relating to explosions. There were 3 explosions between, I think, 1991 or thereabout. Within 2 years, there were about 3 explosions. One was in, the station, the railway station. The other one was in a coach that was carrying some military personnel and their family. And the other one, ironically, exploded at the National Defense College, and that was between 73 and 74. Judith was charged not only with the relation to the explosions, but the fact that 12 persons died in that explosion that involved that occurred at the coach where the soldiers and their family they were traveling in that coach. And so this matter came to court, and Ward was convicted, but the conviction was quashed because scientific evidence or data were withheld because they undermined the prosecution's case. They also withheld interviews and accused statements and medical reports that would have supported his case. And so the Court of Appeal was furious with what happened in that case and quashed the conviction and then indicated non-disclosure is a potent source of injustice. And even with the benefit of hindsight, it will often be difficult to say whether or not an undisclosed item of evidence might have shifted the balance or open a new line of inquiry. And so following Arrow and Judith Ward, I know that the decision in that case also was fairly a little bit refined in Arrow and Davis in relation to sensitive materials. But the bottom line was that this was basically one of the cases that brought very embarrassing results to the system as a result of disclosure failures. And so, it was wake-up call. One everyone will expect, and the UK judiciary, the justice system, the politicians, everybody, rose to the occasion with interventions. And one of those interventions happens to be the Royal Commission. The Royal Commission on Criminal Matters, call it the Ron Seaman Commission. I want to read one or two things contained in the recommendation of this commission. The first thing in one of the criticism or concern expressed reads thus: in addition to the terrorist cases where the convictions were quashed in 1990 and 1991, there had been a fourth case, Judith Ward, where the conviction was quashed in 1992. There has also been a number of cases not connected to terrorism, the most notable example being those of the Broadwater Farm 3, Stefan Kisco, and Cardiff 3. I will mention Cardiff 3 as we go along. And they went on. We strongly support the aim of the recent decisions to compel the prosecution to disclose everything that may be relevant to the defense case. But we accept the evidence that we have received that the decisions have created burdens for the prosecution that go beyond what is reasonable. At present, the prosecution can be required to disclose the existence of matters whose potential relevance is speculative in the extreme. Moreover, the sheer bulk of the material involved in many cases make it wholly impracticable for every one of what may be hundreds of thousands of individual transactions to be disclosed. But at the end of the day, they suggested a two-step disclosure, what they called primary and the secondary disclosure. That was part of their recommendation. But more importantly, their recommendation led to the Criminal Cases Review Commission that was set up thereafter. And more importantly for us in this presentation is the passage of the Criminal Procedure and the Investigation Act of 1996. A watershed legislative response, I should say, to disclosure problems. But again, it required disclosure to be made if, in the opinion of the prosecutor, it will undermine the prosecution case against the accused. In essence, the disclosure test there was subjective, but it remained, as I said, a very critical legislative response to the disclosure problems that UK had been facing. Then in 2003, Criminal Justice Act amended the CPIA and introduced what we now call the initial disclosure and continuing disclosure, a bit of what you may continue to have in the common law anyway, especially the continuing disclosure. And then an objective test was brought in that now requires the prosecutor that it must disclose to the accused any prosecution material which has not previously been disclosed to the accused and which might reasonably be considered capable of undermining the case for the prosecution against the accused or of assisting the case for the accused. That is in section 31A of the CPIA. And so our Criminal Justice Act, as it were, made some amendments to the CPIA and made the disclosure test to be subjective, to be objective, so that it is not left so much in the hand of the prosecutor. Once he considers that it will be reasonably be considered as capable of undermining the case for the prosecution against the accused, and the adds another one, assisting the case for the accused. It must be disclosed, subject, of course, to certain limitations in relation to sensitive materials. And I think our rule has, the rules have adopted to some extent this objective test for disclosure. And then the CPIA also provided a code of practice. It has had several revisions. Code of practice for investigators who must record, retain, and reveal to the prosecutor material they obtained during their criminal investigation. Superintendent Dean Holding will speak a little bit more on this. And you could see that the CPIA and the code of practice, they made provisions for how what I call the first respondents to disclosure materials, the investigative officers, the police officers. In UK, they have what they call disclosure officer, but it just in a name there, and somebody is identified. But that's how serious, they have tackled the matter of disclosure to the point where a disclosure officer is now identified statutorily, to take charge and be responsible to going through and reviewing materials from the very word go, and then sifting through all for the purpose of ensuring that the Criminal Procedure and Investigation Act that requires a disclosure, as well as the code of practice and the guidance that the AG has released, that they ensure that the prosecution is no longer blamed. And of course, they were fighting against another repeat of what happened with the terrorist cases. And so, and then of course, you now have, after that, you'll have the Criminal Procedure Rules of 2005, which has been revised several times and updated. I think the current CPR of UK is 2020, a bit of a consolidation. They are doing now every 5 years. And I think they are very keen on looking at the rules continually to make it relevant to everyday issues arising in the criminal justice system. And so it made copious procedural provisions on both prosecution and defense disclosure. And of course, their reviews and reports and protocols were, arising from UK because of just to deal with, the situation that was faced when most of those matters the convictions were quashed. And so now and again, there's a review. The first one, I think it was the 2011 review of disclosure in criminal proceedings by Lord Justice Gross. There was a further review that he did with Lord Justice Tracy in 2012. His review, I think it looked more at the proportionality of time and cost in relation to disclosure. Of course, it's not just about making disclosures and, ensuring that fair trial takes place. There was an aspect of this disclosure thing that began to overwhelm the system, especially in very large cases, very complex cases. And so they were trying to bring some sanity into this. Reviews will make recommendations as to the way forward. And then there was a judicial protocol on the disclosure of unused materials in 2013. There was a magistrate court disclosure review in 2014, and then Mouncha investigative report in 2017. Very interesting. I must say, the Mouncha, the UK people know this, they will know about this, the trial of police officers. They call them the Cardiff. They started as Cardiff 5 and ended up as Cardiff 3 because only 3 were eventually convicted. And but not the officers themselves. The officers were also the prosecution entered no further evidence in their trial. They were tried because they were charged with perverting the course of justice in relation to the Cardiff 3 trials. Those were persons that were convicted and sentenced for life. But a couple of years later, the actual accused person and perpetrator of the crime came forward, and they pleaded guilty, and I think he was convicted, and the other persons were set free. And so the police officers went to trial. And when they went to trial, the case also collapsed. And the bottom line to all of this, the recurring problem also was disclosure failures. And so the UK had been going through a very stressful period and embarrassing results coming out and leading to all of these reports. Eventually in 2019, they had the National Disclosure Improvement Plan, which reminds me actually of our criminal justice stakeholder group that allows us, the judiciary, police, ourselves, social development, the bar, the private bar, defense bar, represented, and together we collaboratively sharing a common desire, a common goal of an efficient and effective criminal justice system, use that platform. And I think that's what probably happened in the National Disclosure Improvement Plan. They had to come together and to really address the issue of disclosure and be proactive about it. And so that was how National Disclosure Improvement Plan came about, updated up to 2019. And of course, CPS will not be left out. And the CPS disclosure manual that gave detailed guidance to the prosecutors on disclosure. I have gone through this just to highlight where UK had been and what they have gone through and where they are as we speak. It's been a checkered history for them, and from which we are learning so much. I couldn't draft a disclosure guidance without going through and looking at what has worked for them and what didn't work. But even at that, this is our first step in Turks and Caicos in relation to a disclosure guidance. Remember that every facet, every stakeholder in the criminal justice system and the government at large were involved, and in UK trying to deal with this issue of disclosure. And so in TCI, I drafted the disclosure the disclosure document now to guide the prosecutors as well as the investigators. And this is the kickstarting of our training, like I said before, on that document. And so I need to take you to the content. I've been looking at the context, the background, and the early beginnings and the experience of UK, which, as we speak, they probably have, given us a bit of best practice, and so that we don't experience the kind of embarrassing outcome resulted from lack of disclosure. And so I will go into just a headline of the contents of our disclosure guidance, the one that we are dealing with this afternoon. So we are looking at the regime, criminal procedure ordinance, impacts on that disclosure document, the court to give all necessary direction in respect of disclosure by the prosecution, including the date by which such disclosure must be made. Then our criminal procedure rules, rules 45, 79, made additional requirements from the prosecution in terms of the disclosure orders, which should be made by the court. And then you have the legal professions ordinance, very interestingly, also has in Rule 36. I've reproduced it there, just about 75% of Rule 36. The prosecutor must act fairly and dispassionately. He should make timely disclosure to the accused or his attorney, or to the court if the accused is not represented, of all relevant facts and witnesses known to him, whether tending towards guilt or innocence. Where prosecuting counsel has in his possession statements from persons he does not propose to call as witnesses, he should regard it as normal practice to show such statements to the defense. I know we are likely to say, okay, we're doing a number of this, but I think my colleagues and the defense who are practicing here, it won't surprise you, to those of you who are also online this afternoon, that we are having the same issues, and the judiciary will bear us out. We are having issues with disclosure, but probably not at the magnitude that UK have had it. And because we probably learned from them coming a little bit late, not a little bit, we are way, way late in the game. But it has its own advantage, which we are now taking. Of course, the common law disclosure obligation is still there, applies at all stages of a case from charge to sentence, and of course, post-conviction, regardless of anticipated or actual plea. The disclosure guidance is very detailed in relation to what is provided under the regime that we are operating with. Disclosure by defense is Rule 80, and it speaks more of the defendant's statement. And of course, we have the case of Sextus and Attorney General of St. Lucia there. I should say this. Let me read what I have under the defense very quickly. What I have there, it says, bear me a minute, please. Disclosure. The CPR, pursuant to Rule 80, also creates disclosure obligation for the defense. This guidance, strictly speaking, does not govern disclosure by defense. However, consistent with the overriding objective of the CPR, it is envisaged that as Minister of Justice and officer of the courts and a party to the proceedings, prosecuting counsel will assist the court to the fullest extent possible to ensure that the defense also discharges his disclosure obligation pursuant to Rule 80 of the CPR, aforesaid. And in doing so, prosecuting counsel will be well guided by our learning from the case laws such as Sextus Attorney General of St. Lucia. So basically, they are being asked to be alive because the overriding objective requires all of us who are participants in the criminal justice system and in any matter before the court to make sure that we collectively and individually advance the overriding objective. So I will expect not just leaving it to the judges, I will expect my colleagues to assist the court actively in making sure that the defense also will discharge their own obligation under the rules. Of course, there's an ambit to the disclosure regime and is well set out also in the disclosure document guidance. A fair trial does not require consideration of irrelevant material. It does not require irrelevant material to be obtained or reviewed. Prosecuting counsel should not disclose material which they are not required to. And this would because this will overburden the participants in the trial process, divert attention away from the relevant issues, and may lead to unjustifiable delays. And so it's something we do in a thinking manner. It's not a box ticking exercise. Like I said yesterday or Monday, rather, our duty in relation to disclosure has to be very deliberate and intentional, and with the overriding objective of one, to ensure that there is a fair trial for the accused person. And on the whole, we are dealing with criminal matters justly. And we know what that means under the rules. So that is the ambit of the disclosure regime. There is more in the disclosure guidance itself. And in doing so, we are also provided provisions in relation to balancing disclosure duty and right to privacy and family life. I don't know, maybe that's one of the reasons disclosure issues continue to be, an unruling horse. I don't know what to call it, but we are taming it, at least learning from what is happening in UK. I am stunned and actually struck when I was doing the research in what happened in UK, how much reviews, how much commissions, how much, protocols, in the magistrate, in the Supreme Court, almost every arm of the justice system, they were, churning out one thing or the other in relation to disclosure. The CPS in particular issues disclosure guidance on several, aspects of the case, disclosure guidance for the experts who are coming to give evidence or who, will be assisting the courts in progressing cases as from their experts' perspective. Of course, after what happened in, I think it's Judith, because it had to do with scientific and experimental data that were not made available because it was thought to be prejudicial to the Crown's case or the prosecution's case. So there's so much going on, so much, even up till today, they are revising and watching closely what is happening with the disclosure regime. And so in our own document, we have included the fact that investigative officers must be aware of the delicate question which questions that arise when both the right to a fair trial and the privacy of complainants and witnesses are engaged. It is well set out for them there, principles to be applied. Access to material can only be done when in accordance with the disclosure regime, strictly necessary and proportionate, must be pursuing a reasonable line of inquiry in seeking to obtain the material. An assessment of reasonableness is required and must be made on a case-by-case basis. There is still more details and examples given when dealing with the issue of disclosure and investigation when you are trying to access materials that are within the possession of the victim or complainant or witnesses who are not accused persons. All right, so the next content I have in the disclosure guidance, obviously, is the initial disclosure and the continuing disclosure is well set out there as well. The defense must be provided with the copies of access to any prosecution material not previously for the accused, and that continues whether the defense filed a statement or not. I need to emphasize whether they file a statement, a defendant statement or not, the duty still remains on us. Disclosure continues. Duty to disclose continues. So I don't have to overlabor that, and you will see in a moment before I close that it continues even after conviction. Material for test of disclosure. The material that might reasonably be considered capable of materially weakening the case for the prosecution against the accused or of assisting the case for the accused. This is objective disclosure test that is, literally underpinning the obligation. Material may be relevant to an investigation if it appears to an investigative officer that it has some bearing on any offense under investigation and any person being investigated, or on the surrounding circumstances of the case, unless it is incapable of having any impact on the case. Reasonable line of inquiry is that quick points either towards or away from the suspect. This must be followed through. And I hope our colleagues from the Royal Turks and Caicos Island, they are in this room because we have invited them. I need to say that apart from this distinguished forum that we've been given, we intend to continue the training on disclosure after now so that we all get it. Electronic material is also provided, but what I will do is to read out very quickly because of the importance of it in this day and age. What we have under the electronic materials, need to decide how best to pursue a reasonable line of inquiry in relation to the relevant digital material and ensure that the extent and manner of the examination are appropriate to the issues in the case. Must ensure that any line of inquiry pursued in relation to the digital devices of victims and witnesses are reasonable in the context of the likely issues in the case as well. The digital devices should not be obtained as a matter of course, and the decision to obtain and examine a digital device will be a fact-specific decision to be made in each and every case. I can't emphasize that. I'm sure the police officers know that, because it is something you are doing intentionally. You are not just going there and picking up all kinds of things and begin to have problem with disclosure. Must be conscious of the fact that digital devices, for example, phones and computers and similar equipment, are invariably repository of very diverse, intimate, and personal information of the persons, not just the owners of such devices, but other persons who may not be concerned or connected with the subject of inquiry. And that is under the electronic material. More is provided there. Then we have third-party materials from persons and governments and organizations other than investigative officers or prosecuting counsel within and outside these islands. So your reasonable line of inquiry can take you to third-party material. And the principle is to establish a line of inquiry, establish relevance and recording of decision, balance the rights that are engaged in the course of that. Recording of decision is very critical. It's important for us to know what, to record what we have done in relation to third-party inquiries. The third-party materials that we want to get. Sometimes you may be getting a pushback, but what you have done in relation to that is what is critical, is important. And that also includes international inquiries, which normally we will use the Attorney General's office by way of MLAT to approach most of the materials or to obtain them if they are outside our jurisdiction. Another content of the disclosure document or guidance is the non-disclosure in the public interest. And Rule 45(2) already has something to tell to that. It allows the prosecuting counsel to apply to the court for an order to withhold material which would otherwise fall to be disclosed if disclosure would give rise to a real risk of serious prejudice to an important public interest. You cannot forget, we will never overlook the case of Arrow and H and others, where it was laid out, particularly in paragraph 36, the questions that need to be asked by court and the prosecutors and everybody when it comes to sensitive documents that you are saying, although it undermines the case of the prosecution or assists the defense, you will not be disclosing it. Of course, the cases have indicated clearly that the court has to be watchful about that and consider it very closely, and balance it with the need to ensure fair trial for the accused person. The content also has material relevant to sentence, so disclosure obligation continues up to sentence, even after the person has been convicted. Any material which might reasonably be considered capable of ensuring fairness in the sentencing process should be disclosed. This material could include information which might mitigate the seriousness of the offense or the level of the accused's involvement. And so we have that obligation as well. And I just hope that our colleagues also in the police force, they will be conscious of that as well when sentencing is taking place. But this is the other one that by which I'm about to close. Post-conviction disclosure. It is still on us and we can't look away. You can't look away at all as prosecutors and indeed as investigative officers. After the case is finished, the person is convicted, where at any stage, after the conclusion of the proceedings, material comes to light, which might reasonably be considered capable of casting doubt upon the safety of the conviction, prosecuting counsel should disclose such material to the convicted defendant. Of course, you have the case of, the case there is the, let me just, if I may read an extract from that case, the case of Nunn and Chief Constable of Suffolk. This is what Lord Hughes, Justice of the Supreme Court, has to say in that case and in regard to disclosure obligation. There can be no doubt that if the police or prosecution come into possession after the appellate process is exhausted of something new which might afford arguable grounds for contending that the conviction was unsafe, it is their duty to disclose it to the convicted defendant. Simple examples might include a new and credible confession by someone else, or the discovery incidentally to a different investigation of a pattern or of evidence which throws doubt on the original conviction. Sometimes some material may appear unexpectedly and adventitiously. In other cases, it may be the result of a reopening of the police of the inquiry. In either case, the new material is likely to be unknown to the convicted defendant unless disclosed to him. In all such cases, there is a clear obligation to disclose it. And that is the case of Nunn. I just about And in my conclusion, I have just 2 paragraphs. The DPP disclosure guidance provides the practical guidance on the application of the disclosure regime primarily contained in the criminal procedure rules. It has also taken into account, as I said earlier, the prosecution disclosure obligation under the common law, the best practice disclosure regimes, especially of the UK, and the relevant case law on disclosure. My second conclusion is that the disclosure process generally and the DPP's disclosure guidance in particular, they have one purpose. They are aimed at not only securing the accused's right to fair trial, but also to give effect to the overriding objective of the CPR, namely that criminal cases are dealt with justly. Just before I let my co-presenter come in, I need to say to you, like I said before, I am not an expert. Marita, Barra, Casey, and Don Rambo, they have helped me immensely in this presentation, through their seminar work called the Tackling Disclosure in the Criminal Courts, a Practitioner's Guide. It was very helpful to me, and I'm grateful to them for the book that they wrote on this. And I want to say thank you for your patience and for listening. And that is it for me. Good afternoon.
Just do a quick sound check to make sure I'm coming through okay, Mr. Rambo.
Yes, we can hear you, Detective Superintendent. Thank you.
Okay, in that case, I'm just about to share my screen then for the presentation, but for the benefit of everybody who's dialed in, and thank you very much for attending today, I have put the presentation in the group chat as well. Thereafter, I'm also happy to share this by email if people are struggling to access it. And what I would say is that whilst we've got this presentation today, and I'm really grateful for Mr. Otonya's introductory presentation, which was very detailed, there will be further training delivered, certainly to police officers, but some to other law enforcement agencies. So this is the start of hopefully quite a bit of training. I suppose I should start by saying that if Mr. Otonya is not an expert, then I certainly am not an expert. However, before I start with my presentation, my background, despite my youthful looks, relates to 30 years police in the UK. And I was heavily involved in disclosure, both as a dedicated disclosure officer and in latter years as a senior investigating officer. And I have to say that the most frightening thing in an investigation, certainly as a senior investigating officer, is disclosure, because when you look at the statistics in the UK, the number of cases that have failed as a result of disclosure issues are quite significant. So by way of example, last year, the Attorney General in the UK prepared and published some new disclosure guidelines in May 2022. That was as a direct result of numerous things, but not least that in 2021, nearly 1,700 cases for the Crown Prosecution Service collapsed as a result of disclosure. That's not insignificant when you think that actually, as Mr. Otonya's alluded to, disclosure rules started back in 1996, yet the UK policing and the prosecution teams as a whole continue to have real challenges around that. Okay, so I'll just try and share my screen now, if that's okay. Okay, can I just confirm, has that presentation come up?
Yes, it has. Thank you.
Okay, thank you very much. Okay, so this shouldn't take too long, ladies and gentlemen. As I said, Mr. Otonya's given a very good overview, but this is very much more focused on police officers and investigators, and hopefully some of our partner agencies when we move forward. So I think first and foremost, what is really important is that every accused person has a right to a fair hearing, and that is the fundamental basis of this. I'm just trying to move, that's it. And particularly related to Section 6 of the Constitution of Turks and Caicos Islands. And this right is to be exercised, not in vacuum, but within the framework of the administration of criminal law, and the purpose of which is, and I'll let everybody read that to their leisure, but in fairness, fairness is the principal overriding issue here. Principles of investigation, as per the UK Codes of Practice for Disclosure, is that an investigation conducted by police officers with a view to it being ascertained whether a person should be charged with an offence or whether a person charged with offence is guilty of it. I completely supported of that. However, I think it goes further nowadays, whereby whilst we may be looking and very focused on offenders in terms of investigation, the reality is any investigation should be a search for the truth and the establishment of the facts, whether that search leads towards a suspect or determines their innocence. So I think the key principle for investigating officers is that this is actually an investigation into establishing the truth. The principles of disclosure. So the police and the Office of the Director of Public Prosecutions share a common goal that we should have fair and transparent prosecutions of persons who've committed offences in circumstances where it is in the public interest and a prosecution is required. It is the responsibility of the police to investigate offences and the responsibility of the ODPP to give advice on investigations and to prosecute people who are charged as a result. What I would say, however, is even though we've got distinct roles, I do try to engender a very team-working sort of collaborative approach. Certainly on some of the murder investigations that I was involved in back in the UK, I would bring prosecutors into some of those briefings early on so they could at least take some of the investigative journey with us. So when we did turn to them for charging decisions or advice and guidance, they'd had some level of brief, and that's something I want to really encourage here as well. It's team effort. So whilst we have distinct sort of roles within our departments, it's very much a team effort. And I know whenever I've called upon the ODPP, Miss Mills, Mr. Joseph, Mr. Tonya, other individuals, we've always had very good support despite people having very competing demands. One of the other key principles is that disclosure is an ongoing duty. So if further unused material comes to light, comes to the attention of the investigating officer after a file has already been submitted, then the prosecutor should be made aware by the completion of the relevant forms. There is some reference to the 2 forms there, but I'll cover that in a little bit more detail in a few more slides. Now, as we probably know, the UK is governed by the Criminal Procedures and Investigations Act in 1996, and they have 4 defined roles within an investigation. The officer in charge, or otherwise known as the lead officer or senior investigating officer, an investigating officer, a disclosure officer, and a prosecutor. We have, with the exception of disclosure officers, exactly the same sort of roles within our investigations here in TCI. The role of disclosure officer is something that I do want to develop, particularly on major incidents. So going forward, what I'm hoping to is have approximately 2 to 3 teams of detectives within the Serious Command Crime Unit, and that'll include key roles such as family liaison, exhibits, but also a key role of a dedicated disclosure officer who hopefully, with training and exposure to these sort of matters, will become somewhat of a subject matter expert to support other officers around the disclosure regime. That said, everyone has a responsibility to understand and consider disclosure within their role. And I think the key word there is, first and foremost, it's everybody's responsibility to make sure they understand their obligations around disclosure. And then just a few definitions. So in terms of relevant material information, well, what is that? Well, all information and material collected in an investigation will be classed as relevant unless it's not capable of having any impact on the case. So by way of example, very often we can do searches of multi-dwellings and seize a number of exhibits, a number of items. Very often, some of those items are completely unconnected to either the individual that is being investigated or the offences that have been investigated. And the property could actually be something completely irrelevant and belong to an individual or a person who has no connection to the case whatsoever. That's the sort of thing that we're saying is probably not relevant material. And it's really important for people to give clear consideration on what is relevant, because as Mr. Tonya mentioned in his presentation, what we don't want to do is overburden the system with lists and lists of material when a decision can be made at an early stage that actually it's not relevant and is not necessary to disclose. The issue of relevance is very important, particularly when an investigator is considering throwing something away, returning an item to an owner, not to record information, or where not keeping the material or not recording information would result in permanent loss or alteration of the material. So a good example of that is CCTV from the control room or shops or otherwise. So relevant material basically is something that has a bearing on the case. So there's lots of reference around the disclosure test, and in my experience, people can get very sort of confused around this, but the reality is the disclosure test is material that might reasonably be considered capable of materially weakening the case for the prosecution against the accused or assisting the case for the accused. And weakening the prosecution case is as simple as this. Any material which points away from the guilt of the defendant must be investigated. All such material could potentially undermine the prosecution's case and must be referred to the ODPP. An example of such material could be anonymous information handed into the police station that other persons were responsible for the offence. And just on that, one thing that we did encounter in the UK is that as defendants and lawyers, some of which are connected quite closely to organised criminality, realise that there was this disclosure requirement. What you used to find sometimes in some cases is a disproportionate number of calls into Crime Stoppers claiming that somebody else was responsible for the offence. And whilst we could never prove it, there was a strong suspicion that that was a direct act by people involved in the criminality to try and direct away from their guilt, knowing that that would have to be disclosed to the defence, and it could be something that potentially could be used in court to weaken the case. The second part of it is assisting the case for the accused. So an example of material that may assist the defence could be a list of persons present at a scene of an assault who refused to provide statements. It could be details of one witness who failed to pick out a defendant during an identification process where other witnesses did. At an early stage, all material relevant to whether the defendant should be admitted on bail or not. So again, the disclosure test, in simple terms for me, is if I was the defendant or if I was the lawyer defending that individual, would I want to know about that material? Would it assist me? And if the answer is yes, then it probably meets the disclosure test, and there has to be then consideration around disclosure. So what we used to use in the UK, and this is reflected in Mr. Otonya's guidelines, is what we call the 4 R's: retain, record, reveal. Retain, record, review, and reveal. So the first one's very simple. All relevant material gathered during an investigation must be retained. It must be kept safely. If it's physical material, it must be stored appropriately with proper logging of where it's held. If it's electronic material, then it must be stored within an appropriate file on an IT system that is accessible and can be reviewed. The recording of the existence of material and where it is stored and held. So that falls a little bit around the retention. So here in the Royal Turks and Caicos Island Police Force, we use the Altris system. So primarily that is the system that we should use to try and record the existence of all material collected during the course of investigation. In the absence of that, there should be some sort of log or some sort of daybook that records material that has been obtained during the course of investigation. And then arguably the most important part of this is the review process. And this basically requires an individual to ask 3 questions. The first one is the stage 1 question: is the material relevant? If the answer is no, you need to go no further. If the material is not relevant, you don't have to consider anything else about that. It does not need to be disclosed. However, if the answer to it is yes, then there's 2 further questions. The first question is the material sensitive? And does it meet the disclosure test? If the answer to those 2 questions are yes, then we should use the TCI 6. And this is wanting to share confidential information, including material that may be disclosed due to public interest, and also to flag up material that meets the disclosure test. So if those 2 stages, I'll just go back to that. Stage 2 and 3 are a yes, then you should record that on the TCI 6. If the answer to stage 2 and 3 is no, then it can be disclosed on a non-sensitive material schedule. And again, all these forms, in addition to all the other TCI forms, are available as part of the file preparation policy that's been produced some time ago. In terms of file submission, so there's 6 types of files in the Turks and Caicos Island Police and the ODPP preparation case file policy. The initial file where a guilty plea is anticipated, initial file where a not guilty plea is anticipated, an advice file where we're seeking the ODPP charge and advice or other investigative advice, a remand file, obviously where we're seeking remand post-charge, a sufficiency hearing file, which is invariably an upgrade, or a breach of bail file. In all the forms of 1 to 4, a TCI 6 and a TCI 6A should be completed. A sufficiency file is usually an upgrade, so one should have already been completed, And a breach of bail file is a very straightforward case where there shouldn't be any real disclosure issues in respect to that, because it's usually what we would call an absolute offence where there's a breach of bail. And this is the disclosure process in UK Attorney General guidelines that were published in May last year. And again, you can probably see that this follows a very similar process. So you've got all material, some of it will be used as evidence, and then you've got the consideration on the right-hand side in terms of unused material. If it's non-relevant, on the right-hand side there, you need go no further. If it is relevant, then you need to consider if it's relevant, again, is it sensitive material and does it meet the disclosure test? Or is it sensitive material and does not meet the disclosure test, and it should be recorded accordingly. The UK use slightly different forms. However, the process that we're going to follow here in TCI is very, very similar. So in conclusion, disclosure is everyone's responsibility. Whether you're the senior investigating officer or the officer in charge, the investigating officer, whether you're a dedicated disclosure officer or a prosecutor, it's everyone's responsibility to consider disclosure. And that includes that if one of those roles spots an error or an issue, then they just declare that. And at an early stage, a consultation should be conducted with the prosecutor for any advice. And what I always say is, if in doubt, then seek the advice of the prosecutor. Stick to the 4 R's: retain, record, review, reveal. And that's a continuing process. So it's not just one process at the point of which a file is submitted, because very often after a charge is achieved, investigation can continue. So it's a continuing duty to disclose, and therefore we should continually approach it in terms of retention, recording, review and revealing. Ensure that TCI 6 and 6A are completed in every case or every file, with the exception of sufficiency hearings where one should already be in existence, or breach of bail. That said, at the point of a sufficiency hearing, again, the process should have been repeated in terms of reviewing, is there anything new? Are there any new considerations around disclosure? And as I've already alluded to, if in doubt, then consult with the prosecutor for advice. My view is that we should be having far more case conferences, particularly around complex cases. And those conferences should include, I think, discussions around disclosure. And just finally, in terms of some of the stated cases that may be of interest for people, Mr. Otonya has already alluded to the fact that on occasion we may seek to withhold information by way of a public interest immunity application. So this is occasions where we've got very sensitive information that might meet the disclosure test, so it may be of assistance to the defence. However, the sensitivity around that and the public interest around revealing that overrides the requirement for disclosure, and that would require a judge to preside over that decision in terms of what we call a PII hearing, or public interest immunity application. That is born out of a stated case of RVH&C back in 2003, which is basically a case around suspected drug supply. Okay. I'm going to conclude there, so I'll just pause there in terms of anything that Mr. Otonya you wanted to add or expected me to cover that I may have not done, and I'll withdraw from the. I think I've stopped sharing my screen now. I think, is that right?
All right.
Yes.
Thank you very much to both of our presenters, and we now take questions. But before we go directly into the floor for questions, I'd like to read some questions that have been written in the chat. So the first question comes from Mr. Oliver Smith, KC. The question is for either of the presenters. Why is there resistance? Some may argue a refusal to disclose the OTRIX report or record.
I think that's so. That's the that'll be Authoris, won't it? I think in respect of the police system, is that correct?
Yes, that is correct.
Yes. Okay. So I suppose if there is a resistance, sorry, Mr. Otonya, you're all right for me to field that initially? Yeah. If there is a yeah, sorry. If there is a perceived resistance at the moment, that may well be because these new guidelines are new. Obviously, this is the first stage of some of the training, but one thing I've already started dialogue with is colleagues within the National Crime and Intelligence Bureau in respect of significant implications for a consideration of disclosure. What I would say is that going forward, the Otis records, unless there's some level of sensitivity on there, should be disclosable on the non-sensitive schedule. The only time when it should be withheld is if there are some sensitivities in respect of, for example, police tactics or other sensitivities around a confidential source, or sometimes third-party material, particularly from other law enforcement agencies who don't want to disclose that they've had an involvement or otherwise. But if that is the case, that should go on the non-sensitive record. The prosecutor should consider that. And if it meets the disclosure test, then actually, if we want to continue to withhold it, we then should go and apply to the court for a public interest immunity certificate to allow us to continue to withhold disclosure. But I suppose, to answer your question, going forward, some of that should be tidied up by way of these guidelines now, and I would expect that there should be some, for want of a better term, relaxation around disclosing matters to Defence Counsel. I hope that provides some level of answer.
Yeah, I'm comforted by it. Thanks.
All right, thank you. We have a second question coming in from the Honorable Justice Laban Jackson. Under Rule 883 of the CPR, a defense statement disclosure is only required after the prosecution has complied with their disclosure obligations under Rule 79. This sometimes leads to delays. Could the DPP comment?
Yes, thank you. Thank you, my lady, for that question. Let me say, this forum and what is going on here is how we are kickstarting a whole mindset change to the issue of disclosure. If you've read the guidance, at least the draft, it's about 19 pages or so. I heard one of my colleagues actually say to me, we can file a statement because our duty is continuing. And I now knew immediately that something was wrong. But it's not a mechanical thing. It is an intentional, taking on an intentional responsibility and know exactly what you are required to do in terms of assisting the court to make sure that the overriding objective is advanced. So we will begin to do that once we check and there is nothing that we meet the disclosure tests for us to, after the initial disclosure, we must be giving the statements now to the defendant. And I have also indicated that when you do that and it triggers the defendant to file a statement, it helps a lot, because after the defendant has filed his statement, if he's sufficiently compliant, it will cause us to go back to the unused material, because the facts are now and the issues are being narrowed down, and you go back to your unused material and do further disclosure. Although with or without the statement that the defendant has filed, you are still expected to be going through that now and again, reviewing it to make sure that there's nothing there that meets disclosure tests that have been withheld from the defendant. I think it is an issue, it is a matter of mindset change. Look at how far the UK has gone. Look at all the reviews I was sharing with us this afternoon. And yet, Dane is giving us the latest about how many hundreds of cases that collapse as a result of that. So this is a good start for us, and we will always be grateful to the Chief Justice for this auspicious forum where we are kicking off, so that everybody knows that there is a guidance in place, and this is what is informing it. We have our rules, and we need to progress the overriding objective in that rule, and so we are making progress. We will. That's all I can say, Justice Laban Jackson. They will now be guided by the guidance once it is now finally issued. Because I was waiting basically for this, for the discussion here, and to see what the issues are. If I missed anything, it will be included, and so that we have a final copy of it Of course, it will continue to be under review anyway, but it is a first step towards addressing a problem that is not just unique to us as a country. Thank you.
Right, thank you, Learned DPP. And we have a two-part question from Ms. Lara Maroof. The disclosure rules and law are only meaningful and effective if there's a system for recording and documenting relevant documents and information by the police. Does such a system exist? And the second part is a record being kept by the police in a schedule in TCI of all material or information obtained through the investigation?
I can try and field this initially if you like, Mr. Otonya.
Sorry, Dan, you want to go?
Yeah, it's okay, yeah. Okay, so first of all, yeah, a really good question. And as you can see further down in the chat, we do have a system called OTHRIS, which stands for the Overseas Territories Regional Crime Intelligence System. And whilst it's called an intelligence system, it is actually our case management system. I'll be frank, I don't think it's the best system in the world, but having said that, wherever I've worked, I've never been completely satisfied with the IT systems, but it is the system we've got. I think what Mr. Otonya has already alluded to is a bit of a cultural change. We certainly need that within the police service in terms of recording far more, and particularly all the material that is gathered during an investigation onto OTHRIS. And when I say that, I'm not singling out the police in the TCI as particularly vulnerable when you consider, as I've already said in the presentation, that only in 2021, nearly 1,700 cases collapsed in the UK as a result of disclosure issues. So UK policing has still got a long way to go to try and comply with this. And people may be aware of quite a significant case in 2017 that collapsed. It was a rape trial against a man called Liam Allen, who was accused of multiple rapes against a female, only for it never to be disclosed to the defence that actually there was clear evidence on his phone that was never disclosed, which pointed to his innocence, or at least pointed towards consensual aspects of the allegation. So first and foremost, we have got a system. There's a lot of work for us to do internally around utilising that system better. In addition to that, what I'm going to advocate is some bespoke training for individuals who might be identified as disclosure officers. And once we get into that, it may be the case that OTHRIS isn't sufficient for the disclosure responsibility. And if that is the case, we may look at an alternative system or even a dedicated disclosure spreadsheet. And from a personal point of view, when I was disclosure officer many years ago, I used to keep a spreadsheet of that and highlighting, you know, those sorts of different things, highlighting what may be meeting the disclosure test early on. I did mention in my presentation that at the point of file submission, that's probably when we should consider some of the 4 Rs. To be fair, that's probably quite inaccurate. What the disclosure should start at the outset. So even at the outset, if there's something that stands out as undermining the prosecution case, even before we're seeking charge advice from the DPP, we should be looking to making sure we've recorded that, retained it, and in a position to be agile around early disclosure to the prosecutor. So there is a system. We are going to test that a little bit more around disclosure. And if that's insufficient, then we'll probably look at improved systems or actually looking at alternative methods of recording. So I hope that answers your question, Ms. Maroof.
If I may add to what Superintendent Holding just said, Ms. Maroof, honestly, he just told you there is a system and there has been. And that is what gives me some level of optimism, because there is a policy called the Police ODPP Case File Preparation Policy. It took us 2 years and several training, both from locally and abroad. And in the policy, you have schedule of what he was referring to, the TCI forms from 1 to 17. And all of those forms, if they are properly used, as I think they should now, they will schedule materials, schedule, what will be served on you that you may look forward to or you may query. But it's not being recorded as we speak. They are still working with 1 or 2 forms. But once this guidance comes out, and with the kickstarting we've just made today, everybody will wake up, honestly, and begin to put into use, not in a technical, ticking box manner, as I will always say. They have to intentionally want to fulfill the requirements of the rule, of the guidance, and of the policy in a thinking, intentional, deliberate manner. And that's the only way you can give effect to the spirit of the regime under which we are trying to push disclosure. So I don't know whether that helps, so that you look up with optimism, and we'll see where we go from there. Thank you.
Thank you so much, Learn DPP, Detective Superintendent Holden. There's one final question, which I think has to be our last question. It's, why is an intelligence system required to be disclosed? And it's from Mr. Clement.
Okay, well, I'll try again. So actually, having worked extensively in the intelligence world in the UK, there's a misconception that as soon as a system has the word intelligence in it, it shouldn't be disclosed. That is not the case. The guidelines and the legislation talk about material. It's not prescriptive around whether it's on an intelligence system, in someone's book, physically in a store, or on some case management system. Unfortunately, just because it's called an intelligence system does not give us the right to say that it should be not disclosed. And again, this is why there's some serious implications. So any material that we hold has to be disclosed unless there's some level of sensitivity to it. Now, invariably, an intelligence system, and the terminology of AUTRIS is not particularly helpful because it is actually a case management system as well as intelligence, but nevertheless, invariably, an intelligence system does have sensitivities, and providing those sensitivities are articulated correctly on the correct form, then they won't be disclosed, of course, unless it meets the disclosure test. And then if we want to continue to withhold it, we need to then apply for a public interest immunity certificate. Excuse me. So in answer to your question, just because it's called an intelligence system does not mean it's exclusively sensitive, and they will always go on a sensitive material. And again, having worked in that world very often as intelligence manager, we've been contacted by prosecution team to say, is there anything on your system that may be relevant to this case and might meet the disclosure test? Very often there's something that's relevant, but it's sensitive, so it goes on the sensitive schedule, but it doesn't meet the disclosure test in terms of undermining or assisting, and therefore it was not disclosable or required a PII certificate. So I think hopefully that Mr. Clement will, sorry, Mr. Joseph, I think will answer you, or Mr. Clement will answer your question. But like I said, just because it says intelligence on the title of the system does not mean to say that we automatically got some sensitivities around it.
So thank you so much to both of our presenters. And I'd now hand this over to Ms. Tanya Carter, the Executive Director of the Office of the Chief Justice, for a formal vote of thanks. Before I do so, I'd ask all participants to please complete the short feedback survey that I'm about to share in the chat. So I now hand this over to Ms. Tanya Carter. Thank you, everyone.
Good afternoon, and thank you, Mr. Emmanuel. It is my pleasure to give the vote of thanks this afternoon to the learned DPP, Mr. Otunye Casey. We say thank you for taking the time to take us through the history and development of the process of disclosure in criminal cases, which was quite helpful. Your presentation was instrumental in bringing across the importance of disclosure and the potential injustice that could be suffered if this is not done, and the undue delays that may arise as a result. Thank you for all your work in the disclosure process to guide the attorneys and prosecutors and other key personnel on the best practices which are to be followed. To Superintendent Holden, we also say thank you. We say thank you for taking us through the principles of disclosure and for helping us to understand the role we play in the process and what we are to consider when engaging the disclosure process to ensure that it is complied with. To all our attendees, we thank you for your engagement in the process this afternoon. We thank you for your participation and your attendance. On behalf of Her Ladyship, the Chief Justice of the JEI Committee, and the members of the JEI Committee, we say thank you once again. I now hand you back over again to Mr. Emmanuel to close off today's session.
Thank you very much, Tanya, Ms. Carter. So this brings today's presentation to a close, and we look forward to seeing everyone tomorrow for day 4 of JEI Week. Good afternoon, everyone.